morning and welcome. Are you good?
Yes, Chair, we are fine.
Thank you so much. So you are before the Committee on National Economy, Trade and Labor Matters, where we are considering the NAPSA Amendment Bill 2022. Before we go into the submission, the oral submission, which will be led by yourselves, I would like us to introduce ourselves to each other. And so I will request you to introduce yourself to the honorable members, and thereafter honorable members will introduce themselves to you. So when you are ready, sir.
Chibanda Harrington is my name, CEO of Zambia Federation of Employers. I'll ask my colleagues to introduce themselves.
Grace Samoi, Council of the Federation.
Rose Chikotola, Officer in charge of Membership and Marketing.
Thank you so much, honorable members. Let's introduce ourselves to the witness today.
Thank you, Chair. Zambia Federation of Employers, welcome and good morning. Muvika, MP for Shango Monosin Province and a member of the committee.
Good morning, witness. My name is David Mabumba, Member of Parliament for Mwense Constituency, and a member of this committee. Thank you.
Good morning, witness. My name is Elliot Kamondo, Member of Parliament from Fumbwe constituency and a member of this committee.
Thank you so much. Our colleagues who are virtually attending this meeting, do you want to introduce yourselves?
Chair, good morning. I'm Sialubaro Gift, MP for Sinazambo constituency and a member of this committee.
Good morning, Chair. Good morning, our witness. I'm Honorable Njabo Simtowe, Member of Parliament for Bala constituency. Thank you.
Honorable Ronald Chitotera there among us. Okay, at a later stage, we may hear from Honorable Chitotela. Thank you so much for that. Secretariat, do you want to introduce yourselves?
Thank you, Chair. My name's Charles Chishimba from the Office of the Clerk. Thank you.
My name is Nachilima Sinyangwe from ICT.
Thank you so much. And my name is Mtotweka Fuaya, Member of Parliament for Lunte constituency, privileged to chair this committee. I would like to offer you some immunity based on Cap 12 of the laws of Zambia. You may be aware that each time you appear before a committee such as this one, these immunities are extended to you for the purposes of ensuring that the discourse that you tender before the committee cannot be used against you in the court of law, except the committee was deliberately misled. And so I wish for you to take advantage of that. Let me also highlight that we are live on Parliament TV. So just for you to be aware so that you don't get shocked that your submissions are heard by the people who actually constitute Parliament by way of voting these members in. I will request that you walk us through salient features of your written submission, and thereafter I'll ask the honorable members to come through with points of clarification. So when you are ready, please proceed with that.
Thank you very much, Honorable Chair, and we thank the committee for the opportunity accorded to us as Zambia Federation of Employers to actually be witnesses to this very important topic, which concerns the amendment of the NAPSA Act, number 40 of 1996, through what is before this committee, National Assembly Bill number 21 of 2022. Chairperson, we want to indicate from the onset that first, in particular reference to the proposed reduction of the penalty rate, which is currently sitting at 20% to 10%. We want to indicate, Chair, that Zambia Federation of Employers, this is a matter that has been on the table in our tripartite consultative labor council, where we meet with the Minister of Labor, the labor movement, to actually discuss this. And arising from the fact that the 20% penalty as it currently sits has been unbearable in a number of companies, in the sense that in most cases the amount of penalties to be paid exceeded the principal amount by very big margins, such that some companies have gone to the commercial banks to borrow money to settle the NAPSA penalties. A situation which has actually not been healthy for business houses, as it no doubt created extra expenses to the business, in most cases carrying unsustainable debts. Chair, you may wish to know that some good 10 years ago, we did agree in the tripartite that we should actually make this penalty aligned to the monetary policy rate. And we had hoped in the Federation that the minister responsible for labor then was going to actually push this matter forward, but unfortunately it died. We are therefore grateful as Zambia Federation of Employers that we now have this matter on the table being discussed, that there must be a consideration of reducing the penalty from 20% to 10%. And therefore, as ZFE, we welcome this move. We support it because we know that it has a positive effect on the growth of businesses, which no doubt will also culminate into employment creation. Our belief, Chair, is that when the cost of doing business is actually affordable, it creates room for business expansions, and it is through that process that we can see jobs being created in the private sector, because private sector will take their rightful role to actually make a contribution towards the employment creation. And so we are actually in support of this proposal, and we actually wish it had already been passed. Chair, moving on our paper on page 2 to discuss the insertion of a new subsection immediately after section 2. This is in regards to the issue of waiver, where the bill is proposing to give the powers to the management of NAPSA, DG, to be able to waive penalties. Again, Chair, we want to inform this committee that in the past as ZFE, we've had our members, those who received these huge penalties, coming to ZFE to ask ZFE to engage NAPSA and see if there could be a possible way of waiving those penalties. But the hiccup on the part of NAPSA management currently is that the Act does not provide any waiving power. And to see this being proposed is a welcome move, Chairperson, that even when companies may owe, even at 10%, there are times that there are ups and downs of business. Cash flow constraints come at play, and therefore companies may reach a point at which their cash flows do not permit them to actually settle those penalties. But if the DG is given the waiving power, we think that it will then be a consideration of case by case to see what were the reasons behind the delayed remittances that might have caused the penalties to have been passed on such entities. And also going by what the minister may prescribe in the statutory instrument in terms of grounds for giving this waiver. We think that it's a step in the right direction, and we welcome it, and hope that this will actually be passed by Parliament to be an inclusion in the bill. Chair, I want to give you an example of the current practice at Zambia Revenue Authority. As you may be aware that when an authority is pursuing a debt from a defaulter, at times it becomes a court case, and there are huge legal fees that are actually made. So when there is a waiver, it actually helps such authorities, like in this case we talk of NAPSA, to save on legal expenses. So it's actually a benefit that will not only be accruing to employers who will be found in this situation, but it will also be a benefit to the authority itself, because there will be less work for them, for the management to pursue those huge debts, and like I said, also no legal fees to be incurred in pursuing those cases in the courts. So we welcome the waiver aspect, Chairperson. Next, I want to talk about the proposed repeal and replacement of Section 39 on the one-off age benefit. We note, Chair, that the bill has proposed attainment of age 36 for one to qualify for the one-off age withdrawal. And it has highlighted that one should have made contributions in the fund, which is an obvious case. So, Chair, while we do welcome this one-off age benefit under the existing fund, where that person attains a minimum of 36 and has made contributions to the existing fund, we propose the following: that the age at which a member must qualify for a partial withdrawal be increased from the proposed 36 to 40 years, and that the act to be passed must prescribe the number of contributions in terms of months or years as a minimum number of contribution into the pension scheme before a member qualifies for age benefit withdrawal. And to this effect, we are proposing, Chair, that a minimum contribution of either 120 months or 10 years should have been made by a contributing member for such a member to now qualify for a one-off age withdrawal. This proposal, Chair, is based on the fact that while we're trying to provide an avenue for members of the scheme to have access to some money, which of course they may want to invest in various projects, we should be mindful that for the scheme to be sustainable, it needs to have these contributions made within a reasonable period of time. We think that a 10-year period or 120 months will provide good period for the scheme to invest those funds, such that at the time that someone is making a withdrawal, is not withdrawing from other people's contributions, but is withdrawing from his own contributions into the scheme, where the scheme has invested and there are some returns. And in any case, Chair, if there is to be a statutory instrument that the minister will prescribe, and the minister may decide to put a certain percentage, we've actually heard in the media that the current minister said they only be able to withdraw 20%. 20% of what? So the fund should grow. It will work towards, to the advantage of the members that are withdrawing when the amount of money has grown. So even when you say 20% of X, it's 20% of a reasonable amount of money, which is a component of the contributions and the returns that have been generated by the fund. So we think that that is quite critical, so that then we do not risk a situation where the fund starts reaching a point of insolvency. Okay? It should still maintain a sound financial position to be able to actually afford those partial withdrawals. Chairperson, in moving forward, we note that we want to make a proposal also that other than what has been proposed, the one-off age withdrawal, we believe that if by now NAPSA had innovated to the extent of having created a loan facility to its members, perhaps today we could not even be talking about this partial withdrawal. And therefore want to recommend strongly that this be considered as an option, because we know that currently NAPSA puts money in commercial banks, and the members of NAPSA borrow those funds from the commercial banks at high interest rates. So NAPSA can create a loans facility and lend its members at the same rate that they are lending the commercial banks. So that could be another way of looking at it, where if people can access some funds from NAPSA, other than the so-called partial withdrawal, through loan facilities which are actually at an affordable interest rate, Chair, we may even reduce on the number of the people who will go for the partial withdrawal. Because what must be understood is that when one has made a partial withdrawal, effectively it means that the future pension earnings from the scheme at the time of retirement will be reduced with that amount of money which will have been withdrawn at the age of 40, which we have proposed. So it can be an option that I can decide, should I go for this partial withdrawal or should I go for a loan? Because I also want to look at my future earnings. It may sit well for me to opt for a loan, which I may pay off during my working life, and then I don't disturb my future pension earnings. So, Chair, that is what, as your federation, would like to propose in our input to this bill. Let me, at this point in time, Chair, ask my colleague, legal counsel, to also make a few points. Thank you.
Thank you, Chair. My comments are in relation to the proposed amendment to Section 39, the repeal and replacement. There are a number of issues which are not clear, and this being such a fundamental provision, very quickly, the first one is in relation to subsection 1B, contributions to the existing fund. We have proposed that there be a minimum number of contributions, and it's not just a case of the sustainability of the scheme or the ability of, yes, the sustainability of the scheme. It's also a case of, that is a question of substantive law. It should not be sitting in an SI. SIs are for administrative implementation of a statute. And in the same way, the parent act, the main act itself, says 180 contributions. Even this age benefit should have an express number of contributions. So in relation to paragraph B, we have proposed 120 minimum contributions, and we propose that that sits in the act, in the bill itself, not in an SI. The second issue we have is with the proposed subsection 2 to section 39. A person who receives a payment under subsection 1 shall not be entitled to a further payment of a benefit. As much as there's a direct connection to subsection 1, we propose there's a bit more clarity there to make sure that that is the one-off or the age benefit. Otherwise, it ends up looking like there's a risk you might not have your pension at the end of the day. So that's a case of clarity. Coming to subsection 3. This subsection is actually the most difficult to understand. The minister may prescribe the conditions for qualification of entitlement of a benefit in respect of a member who is above a prescribed age. There's already a minimum age set under the proposed subsection 1, so we are not sure exactly what the prescribed age is going to do in this context. Paragraph B is the most difficult. A member of the existing fund may convert the amount in their account into pensionable employment for the purposes of pension or invalidity pension in accordance with the described formula. Does this mean that while you are still of gainful employment age, you can convert your money into the pension? This just requires a lot more clarity for us to understand what it means. Paragraph C. The manner of transfer of pensionable employment in respect of persons covered under other pension laws. Chair, this sounds like it's a backdoor way of addressing what was going through the Social Protection Bill a few years ago about bringing the other schemes into NAPSA, PSPF and LASIF. And it cannot be done by an SI for the minister to prescribe ways in which other pension scheme members will be brought in. That is a case of substantive law that needs to be addressed very, very carefully. And so we have a red flag on paragraph C, and we would recommend that it be given much further examination, and also perhaps the Ministry of Justice and the drafters can be clear on exactly what is intended here. Because if it is an attempt to pull in members from LASIF and PSPF, because that's what pensionable employment means. Under Act number 40 of 1996, pensionable employment is employment in respect of which contribution is payable under this Act. And then C says the minister may prescribe the manner of transfer of pensionable employment in respect of persons under other pension laws. It's a lot of caution needs to be, when you start referring to other pension laws, given the difficulty that we have. Initially, the understanding was NAPSA is going to take over everything. Over the course of time, I believe there was an opinion from the Attorney General which actually said, no, NAPSA is not supposed to take over everything. The others exist contemporaneously. Then there was the Social Protection Bill, which had a tier system which said NAPSA on top, then the others as occupational pension schemes, private schemes, and LASIF and PSPF in the middle, and then the third tier as well. And so paragraph C is something we are really concerned about in relation to the whole scope of pension laws, and it needs to be given much further consideration. Thank you, Chair.
Chair, before we hand over, in our conclusion, we are aware that there have been some divergent views from members of the public in regards to the issue of the one-off age benefit, where some have argued that when people get money before they retire, they will squander that money and then making their future bleak. It is true, Chair, that money can be squandered at any time. Someone can get money from a pension at an early stage and squanders it. Equally, even when one gets money at the right time, can still squander it. That if that person's mind is about squandering money. And for that reason, it does not matter at which stage one gets money. But what matters, perhaps, are issues of financial literacy. So we are recommending in our point number 5 that NAPSA should actually come up with a financial literacy program to be attached to the one-off age benefit to minimize chances of some people misusing their money once they have received it from the scheme through the one-off age benefit. Chair, financial literacy is a wide topic, there could be a lot that can be covered in financial literacy. But what is critical is to make people realize that they should spend money wisely. Make people understand various business opportunities which are there, that you can get your money from a pension scheme and you can still use that money as capital for a business and manage a business in a proper way that it can actually sustain you in your old age. So we think that component is very, very important, Chair. So that concludes our submission. Thank you very much.
Zambia Federation of Employers, I would like to sincerely thank you for your submission. I think though it was very insightful, and honorable members should be happy to make follow-up clarification points. The penalty from 20% to 10%. Someone indicated to me that 10% is still a bad ratio. Why don't you take it down to 5%? It's just a comment I would like you to offer. The council talks about all the ambiguities and lack of clarity in the text, and she establishes where she thinks there's literally no clarity. In her view, given all those issues which require clarification, what is most appropriate? Redrafting or amendment of the bill? Amendment of the amendment bill. Honorable members. Okay, take those while the honorable members are still thinking.
I'll go first, then Council will take the other one. Why not 5%? Well, there's a view from certain members of society that for employers to be committed to remitting the pensions, you know, as you are aware, this pension is a 5% employer, 5% employee. There are those who think that if the interest rate, the penalty, is too minimal, employers will relax and deliberately delay the remittances. After all, they'll be saying the penalty is affordable, we can pay it. That is one side. But we think that it shouldn't be like that, because you see, corporate entities are supposed to operate on a manner that they uphold the governance issues. And to be current on liabilities that are involving employees is actually a responsibility that employers should uphold in high esteem. So to argue that, and then it will actually be, for us as employers, we'll have no problem with the 5%. We'll actually jump on it if this was the way to go. What is important really is to look at it from both ways. What is it doing to the pension scheme when delayed remittances? In fact, Chair, the reality is that those funds, when they are collected, they're supposed to be invested. So what is the rate of return? That is critical. So is the penalty that is being charged equivalent to what could be realized if those funds were invested? So I think that is where we should now be looking at. So what is the internal rate of return for NAPSA? And when they do their investment appraisals, what is their NPV rate? So that then we are able to say that if a 500,000 was delayed by company X for say 1 year, how much would have NAPSA made on those funds if they came in and they were invested for 1 year? So if it can give us a 10%, then we'll be saying it's in order for the company to be penalized up to 10%. But if it will give us less than 10%, then it doesn't make a business case to actually penalize an employer more than the returns that would have been yielded had those funds been invested. So either way, Chair, let me simply say, we'll jump on the 5% if you could push for it. Thank you, Chair. Council?
Chair, in relation to the question of whether redrafting or amendment, given that this bill is already in the process, and we've been in places like this before, where we submit, and then fortunately, by the time it reaches third reading, a lot of those changes have already been incorporated. So our recommendation is amendment, more in line of, I mean, some of the issues like subsection 2, further payment of a benefit. That's just tweaking the language to say the age benefit. That's, you only get it once. Subsection 3, where there are the big issues, I think it's really just tweaking the language to be clear, or in relation to subsection or paragraph C, really just to be a lot more careful about the legal implications of that. But otherwise, I think amendments, once the drafters sit down again with the sponsoring ministry to again be clear and of course propose them to the House for the committee to take it through. I think just amendment, cleaning up the language a bit in the act will make it, in the bill, will sort out some of the issues. Thank you, Chair.
Thank you so much. Honorable Kamondo.
Thank you, Honorable Chairperson, and I'd like to thank the witness for the elaborate provisions that you have provided to us, which are going to be very helpful indeed. The people out there, they are listening. And then maybe many people are also interested actually to know. They may not have the chance to ask. But on behalf of the people, I want to take you to the pure and replacement of section 39, one of age benefit. You have suggested that the age be lifted from 36 to 40. Yeah, and you have given actually very good reasons, of course. However, I wanted to find out how did you arrive at 40 and not 45? Because currently, most of the employees, some of them may not have had the chance to start work maybe at 25 or even at 30. Many are starting maybe at the age of 35. Of course, I take note of the 120 months that you have also provided here. However, I wanted to find out why not even 45? Because early retirement is at, I'm sure it's at 55. Then the other one is at 60. Then full retirement, I think it's at 65, if I'm not mistaken.
Yes. Full retirement.
60?
Yeah, late retirement 65.
60, yeah. Now, I want you to elaborate further why you think 40 is better than maybe 45. That is number one. Number two, you are also saying that why do people actually contribute to NAPSA? And NAPSA also lends its money to banks. And the same people that are contributing, the members, go to the banks, the commercial banks, to borrow at a very exorbitant, maybe I can say, interest rates. And you are proposing that it would be maybe ideal for NAPSA to start loaning out, to come up with a loan scheme to loan to its members. Then the question is, when would one be eligible to get that loan facility? Maybe if you could just provide more clarity so that members are able to hear and the citizens are able to hear whether this provision which you are proposing would be beneficial. Definitely to be beneficial, but could you just elaborate further? Thank you.
Any further comment? Honorable Mavumba.
For me, Chair, in one of the submission, I think it is on page 3 of their submission, I want to pick the keywords where they are talking about the scheme must remain financially sound. Now, as Zambia Federation of Employers, obviously your worry is that the scheme has to remain financially sound and sustainable. And in the corridor of the corporate governance, I know you compare notes, really. Have you been consulted in terms of this particular bill that NAPSA has brought before the August House, in terms of, was it based on empirical evidence that even at 36 years you can withdraw your benefits, not taking into account even one of your proposals that you have made to say maybe probably should be tied to the number of contribution one particular member has made. So what I want to find out is in your corporate governance, you know, as you chart, has there been any substantive consultation that has been done based on this particular proposal in terms of the bill that has come before this August House? Number two is on the, I know Honorable Kamondo also referred to this loan. You are saying if an insertion of the loan option. So in your proposal again, are you suggesting that it would be ideal to have both provisions, the loan facility as well as the partial withdrawal of a member's benefit? For now, Chair, I end there. Thank you.
Thank you so much. Please take those points of clarifications.
Thank you, Chairperson. So we go back to the issue of the age. Actually, I want to emphasize, Chair, that while we've spoken about age 40, the number of contributions into the scheme are quite critical also. So we are marrying both the age 40 and the contributions of 120 months. Now, the question is, why did we choose 40 and not 45? Yes, it's true that people are getting employed at different ages. But we worked on an assumption that if we picked on an ideal situation where I would say that at age 25, someone should have completed tertiary education and should be getting into employment. So if one got employed at age 25, at age 40, one will have contributed for 15 years. Now, you may wish to know that the current Act provides that when one has contributed for 15 years, which is 180 months, one qualifies for a pension when you retire. Okay? Plus age. And so we are saying at that point, when you have done, you've reached age 40, we assume a contribution of 15 years. You've actually made a significant contribution that has already qualified you to get a pension when you retire. So when you do this partial withdrawal, you have your future contributions into the scheme for as long as you remain in employment. So the scheme is not being starved because of fulfilled the minimum requirements for you to actually be treated as a pensioner and be on a pension at the time of your retirement. So that was our thinking. At age 45, you'll be actually going beyond. It is delayed because, you've made meaningful contributions. So, Chair, that was our thinking on that aspect. And then the loan facility. Should it be both or just the loan? I think we are proposing both. That let this proposal for partial withdrawal go through. But we are saying, can it be also supported with a loan facility? And in our submission, we are saying, let people have an option of either going for a loan or going for the partial withdrawal. So it will depend on what one wants. Because it will also help actually reduce on the numbers of people who would want to rush for a partial withdrawal, and that will work to advantage of the scheme. In any case, that loan, again, it is not for free. It will be given at some affordable interest. So it will be actually an income generating facility for the scheme. Have we done any empirical evidence? Have we been consulted? That is coming from Honorable David Maumba. I think I would like to say that, frankly speaking, when we are dealing with the pension schemes, professionally it's advisable that you rely on actuarial valuation reports, which will tell you where the fund is sitting, its liabilities, its solvency, and then when you are proposing something, like in this case, when we say withdraw at 36, is the actuarial valuation telling us the parameters, the considerations, the assumptions that must go in to tell us that if people withdrew money partially at age 36, it will not do any harm to the scheme, or will it be doing any harm to the scheme? We want to believe that even when the drafters of this bill proposed 36, we do not think that there was any actuarial valuation that informed into that. So our 40A, which we are proposing, like we have explained, we are actually just fine in terms of the number of months and years that one will have pushed into the scheme. And that will be addressing the sustainability of the scheme. I think that is where we are coming from. I don't know, Councillor, if you have anything to add. I don't know if the members are okay with those responses.
Yeah, yes, and thank you so much once again, Zambia Federation of Employers. Your contribution to this committee is highly valued. It will certainly go a long way in informing this committee as it comes up with recommendations to Madam Speaker. We'll end here now, and I'll let you go. Just before I do so, allow me to withdraw the immunity, which I conferred upon you, and I do so in your best interest, so that you can go back to the offices, light shoulders as you came in. So please do have a good day. We really appreciate your contribution.